Okay, so my name's Kyle Herbert. Thanks so much for coming. We've got like 20 or 30 people supposed to be here live, which is an incredible turnout. I think some more people might trickle in, although I think some people might just show up for the cocktails and food after, which is fine as well. We've got about another 30 or 40 online. So everybody watching this online, where's the camera? We are super happy to have you here today from places all over Austin and all over Texas. Let me begin by thanking our sponsors. Jeff is here with Pipkin's Investigations and Val from Oasis Financial. We couldn't do this without their support. They're going to be around. So if you have any questions for them or would like to do some business with them, they would love to chat with you, and they will be upstairs. They bought our lunch and most of the booze. So be sure and tell them thanks and please chat with them for a few minutes before you go. The CLE today is about the Alex Jones InfoWars trial. And so I'm not going to tell any of that story. I'm going to let these fine folks do that. This is Mark Bankston, Bill Ogden, and Kyle Farrar from Farrar involved, who've been handling this case for years and years and tried it in Austin. Was it last month? Yes, a couple weeks ago. I'm supposed to, raise this one caveat, which is to make sure everybody understands. In this case, the defendants defaulted on liability, I believe, because of a long history of discovery abuse. And so these guys may show a few video clips of depositions, and some of those questions would probably be way out of bounds for a normal trial. And I have been told, since we have a couple of judges here, that these fine attorneys would never attempt such shenanigans. Anyway, thank you all for coming, and hopefully you can spend some time with us. With that, I don't know who's going first. I'll start off. Let me introduce Mark Bankston, a friend, a fantastic lawyer, slayer of all things InfoWars. Take it away, Mark.
So it's been a long journey. We picked these cases up in 2018, and having them now just be concluded at trial, we're anywhere closer to being done with Mr. Jones. We still have, some of y'all may know that they're picking a jury right now for another trial. Parents. We also represent another set of parents who are hopefully going to be tried before the end of this year. We also represent a young man who was falsely accused of being the partial shooter. Has never even been to Florida. Was sort of singled out by a gutter website, and InfoWars just ran with that. He was actually the first person to bring a defamation lawsuit against InfoWars in 2018. Because he did, and we brought those suits, Sandy Hook families came to us. Right now, we put Mr. Jones into bankruptcy, so he's put his companies into a bankruptcy proceeding. We're chasing him down through all of that. It's nice to have a verdict, but it's certainly not the end of the story. We're going to be doing a lot more. We're probably going to be dealing with this probably for the next year or two, chasing him throughout different courts, and hopefully disgorging every asset he has. So what we wanted to come talk to you today about, there's a couple different things we're going to be talking about. One of the things I'm going to start first talking to you about is one of the unique challenges of this case was how to deal with trial publicity. Every attorney from time to time has had to deal with the press. This was a whole different animal, and it made us have to learn those rules a lot more thoroughly than we perhaps would in other cases. So that's where we get our little ethics credit for today, because I'm going to be talking to you a little bit about the ethics of dealing with media in a case like this. Once I'm done, Bill is going to be showing you a little bit from witnesses in the case. As we said, they were unusual witnesses, unusual depositions, but some of those tactics can be used just about anywhere. Plus, and in addition to this being continual legal education, there's also going to be some continual legal entertainment out of this, because those depositions are kind of fun. And then Kyle's going to talk to you, I guess, about what turned into maybe the biggest bombshell out of this, which was the inadvertent disclosure of that. And that, as some of y'all may know, and I'll prepare you all for this, is that shortly before the trial began, Mr. Jones's attorneys accidentally, inadvertently sent us a large volume of files, which included all of Mr. Jones's text messages from 2019 to 2020, completely raw of them, after having denied that relevant text messages exist. And so that was a confrontation at trial that happened. Kyle's going to be talking to you a little bit about that, how you deal with that, and how that ended up turning out at trial. But first, I want to talk to you about trial publicity, which is, in a lot of your cases, you may get interest from the press, and in general, the problem is that the rules about what you can and cannot say to the press are not as solid and not as firm or understood as we'd like them to be. Most of you are probably familiar that there is a disciplinary rule, and it's disciplinary rule 3.07 on trial publicity. There are certain things in that rule that you're just not allowed to talk to the press about. That rule, however, though, plays into tension with your right as an attorney to come to the press. You have certain unalienable rights to free speech that may not exactly jive with what the disciplinary rules are asking you to do. But first of all, basically off the disciplinary rules, the number one thing you're going to have to remember about the disciplinary rules is there are certain things you cannot say about the opposing party. The biggest one being is you cannot give your opinions as to the credibility or honesty of the opposing party. Obviously, in a case like ours, that's going to be very difficult because your cause of action is that your opposing party is dishonest, that he committed an act of dishonesty. So there already you're going to have some pitfalls in trying to talk about it. There's also things you cannot do in terms of talking about what you expect the anticipated testimony of the witnesses. You cannot make certain statements that are going to introduce what you know are inadmissible matters. So if you know that there are certain things that aren't going to be able to come during the trial and you start saying them to the press, that can get you in trouble with disciplinary rules. The big problem with this, though, is that the rules themselves have comments that recognize that there is this inherent tension between what an attorney can do under the First Amendment and what disciplinary rules require. There's a rather famous U.S. Supreme Court case that any lawyer who deals with the press needs to know about, and that's Gentile, right? And that involved in that case was statements made by a public defender who was trying to counter statements made by the prosecutor. This is where the tension really arises, is that say you've got a prosecutor out there saying crazy stuff about your client. If you don't go out into the media and make statements like this, you have seriously failed your client. The Supreme Court recognized that you do have duties to your client to control the narrative in the press, to control what public relations are. In fact, in a lot of cases, you can actually, when you're recovering attorney's fees, and this is something you have to look at, you can actually claim your time talking to the press and dealing with press inquiries as attorney's fees recoverable in cases, because those are reasonable and necessary for the provision of legal services to your client. But what happens when you are suing somebody like Alex Jones, right, whose entire modus operandi is to use the public press and his media organization to talk about your case? What the rule recognizes is that frees you up quite a bit, right? So if Jones is out there and he is saying things that arguably violate Rule 3.07, and he's out there causing prejudice to your clients by saying things that are false about the case, you are unshackled as an attorney in that. You are under our disciplinary rules, and you can look at comment 3 on this, so you are allowed latitude to break the rules, essentially. You start talking about these matters if it's reasonably necessary to counter other speech that has been made about your case. So that's what we saw in our case. Our case, it was sort of extreme. You know, a lot of times you might have somebody saying things like, oh, you don't have merit to your claim. It's less common that you would have an attorney saying about the other side that they're all a bunch of goblins, that they smell of sulfur because they're part of Hillary Clinton's cabal with the devil to kidnap children, and I mean, it goes on. That's like literally what you're dealing with. When you're that far outside of it, when you're that far outside of what is traditionally allowed, all of a sudden it becomes kind of anarchy, and that can be dangerous as an attorney, because now all of a sudden you have people who want to cover your case. They want to tell the story they want to tell, which is not always the story that you want to tell. And so you're going to have to be very, very careful when dealing with it. This isn't even just on a case like Jones, right? You have a case like Jones, clearly there's going to be massive media interest. But just about any case that you're going to be dealing with here in town, for instance, that the Chronicle is going to cover, you've got to...
Mark, could you speak up just a little bit louder? I think the folks on the...
on the live stream, huh?
Yeah.
Yeah. No, get it. See if we can get the mic level up here. One of the first times I've been not accused of being loud enough.
What?
But yeah, we'll see what we can do.
Thanks.
So, all right. So really, the problem that we faced in the Jones case is that there was so much going on. Sorry. All right. There we go. The problem that we really had with the Jones case is there was just too much media. There was too much media interest. And you have to remember that you're faced with a double-edged sword here, because on one hand, you want to get your client's story out to the media. You want them to understand what's going on. You want your potential jury pool to be informed of it. But you don't want your jury pool to be too informed of it, right? Because if you have too many people sitting on that jury pool who know too much about your case, those people are going to start getting struck off your jury. And this was actually a real concern because in most cases, you're like, all right, if you can get a little bit of press in the media, you can almost subconsciously plan it in your jurors' minds. But when you have jurors showing up and they've been following everything, all of a sudden you have different considerations. So while on one hand, you want to be able to talk as freely as you can about the case, you really want to be able to do that. We knew in this case that winning the public relations war too much is actually going to hurt us with our jury pool. Luckily, when we ended up at trial, we started picking that jury, we discovered that even the jurors who had understood about the case and its coverage generally decided to stay quiet. I was really shocked at the amount of jurors who definitely knew everything about the case and decided that they were going to in Farrar and not say a word. You were going to have to really pull teeth to get them to talk about it because they wanted to be on that. So that was a concern for us for a while, but ultimately that sort of worked itself out. The biggest thing that we really, I think, had to worry about in terms of trial publicity. Yes, Judge?
How did you know they knew all about the case?
Well, when we had a very, very exhaustive Farrar. And one of the great things about it is we had a jury questionnaire beforehand, and it was a really solid jury questionnaire. We were real surprised we got them to agree to it. So that they're at the edge of trial, they were panicking. They didn't have a lot of time to look at stuff. So we were able to, most of the things that we would spend a lot of time in Farrar actually were already covered on the questionnaire. And so during Farrar itself, to talk to the jury about what they knew about the case, that was what we spent most of the time on. Right? There are two big topics that we did on that. And one was the jury's ability to award emotional damages. That was key, right? You've got to get the strikes for cause out on those people. And so that's what it was. And I think out of a jury pool of 100, our partner Wes got 25 jurors struck for cause on that issue. And so they're just wiped out all those kind of jurors. But then what we would try to do is isolate those jurors who had heard of the media coverage and then basically inoculate them with strikes for cause. And so you kind of knew what the media coverage was and you could kind of feel around the edges of it without talking about impermissible issues. For instance, you weren't able to talk to the jurors about did they know Informer's financial state, but we knew that had been widely reported on. So you try to get them talking a little more about those issues. They spoke up a little bit, and when we were able to recognize a juror who knew what the case was about, it was pretty easy to inoculate these things. Because the thing you were dealing with in our case, and I mean, this drips a little bit off of publicity, but it was, if you think about normally when you're talking to a juror about a defendant who is a pariah, who nobody likes, right? The problem is that juror's going to be prejudiced because they're going to be like, I don't think that I could come into this court and find that what he did wasn't wrong, right? There's a lot of jurors who felt that way. I know what he said about San Diego. You could never get me to say that wasn't wrong. But in our case, when we had this default, you could say to every juror, nobody's ever going to ask to find that what he did was good or not somewhat excusable. Instead, it's only about the amount of damages. And so we were able to get really high quality jurors this way. That jury pool was an excellent pool. But a lot of that was the fact that we were spending 4 years of having to frame this message. And really what it comes down to is when you have to deal with the media that much, when you have to be telling the narrative of your case, it forces you to do what everybody's told you in every CLE about trial skills to do, which is to create a story for your case. It's already going to be created by the time you walk in the court because you've been having to do it for years. So that's what we did. In other words, what I think the biggest message I want to send away from you is a lot of you are going to have seen us in the media and how we've dealt with the media on this case. Do not take that as a blueprint for how to do it in your cases, because you are probably not going to be suing Alabama. And therefore, you are not going to have a defendant who is going to unshackle you with the media to that extent. Always keep an eye on. Do not in any way attack the honesty of your opposing party. And do not comment on what your witnesses will testify to. Remember that if it's in a pleading, if it's in a deposition that's been filed with the court, that's fair game. All of that's public record. If you can accurately report a public record, you're always going to be okay inside of Rule 3.07. But be extremely careful with depositions that have not been filed with the court, with discovery that has not been made part of a pleading. Any sort of unfiled discovery is where you could get into some real trouble. So we hope you have enjoyed some of our antics on the national media as this case has gone along. But remember, when you do media attention in your cases, look at Rule 3.07. Make sure you're always inside that rule. With that, I'm going to turn it over.
Quick question. Yeah. Does it matter in your thought process whether the person that's sort of opening the door for you to be able to talk about it in a way that sort of violated 307, but because they've opened the door, you can? whether that was council versus the party, because in this instance, it's Alex Jones himself primarily versus his attorney. Did that factor in?
Well, part of actually why we were lucky is that, I don't know how many of y'all know this, but Jones has had 10 different lawyers over the course of this litigation. It's wild. But several of those lawyers were actually InfoWars commentators. They would actually appear on the show with Jones and talk about the case. And I can't tell you how lucky you are when your opposing counsel is literally an InfoWars commentator. That you don't get like you're that. In that case, that kind of made the decision for us. But I do think it's important. Because I think, for instance, a party is going to have greater free speech rights and maybe more leniency to violate those rules than counsel. If it's your opposing counsel, yeah, you definitely, they've unshackled you. They've opened up that rule. The other thing that brings up too is that because there are these vague questions like that, there are a lot of questions where things are unsettled. The tension between the Constitution and Greece 107 hasn't been resolved. If you start getting close to those edges, you are inviting litigation. And you may be right, but it may be more work. You may be facing a motion for sanctions in your court. You may have some attorney who on the other side of you is such a bad guy that he wants to report you to the bar, and then you have to deal with some bar stuff. And yeah, you're probably going to be vindicated. But ask yourself, is the fight worth it? So with that, I just say, yeah, know your rules under 3.07. And do get into it like options. Yeah, have fun. But otherwise, be careful what you say to the media for sure. I'm going to turn it over to Kyle, who's going to talk to you a little bit about inadvertent disclosure and some stuff that happened at trial.
Yeah. Do you have the PowerPoint up, Andy? So anybody who's watching the trial probably realized that we got this massive amount of data that was inadvertently produced to us the week before trial. So Mark and I are actually driving up to Austin Wednesday or Thursday, and we get this download or a Dropbox from defense attorneys, and it says it's for us, it's to us. We send it to our office to start downloading. We get a call. We're like, look, this is more information than our server will hold. This is an insane amount of data. And I'm not positive that it was meant for us. So we're like, well, what's on it? Like, well, it's all this text messages between Alex Jones and Roger Stone, and Alex Jones and Tucker Carlson, and Alex Jones and his dad. And his dad's kind of shouldn't be in public forum, but a little bit out there himself. Gotcha. So Mark and I, we're literally just driving to Austin, like, well, we're definitely not supposed to have it. And I sort of remember there's rules on this. I'm like, there's some rules. We'll think about it. And it's 10 days, right? So we have to notify them that we've gotten something that we don't think we're supposed to have. Because the clock starts whenever the defendant or the producing party realizes that they did something that, was inadvertent. So if they realize it themselves, the clock starts, or if we notify them. So we send an email and say, hey, we think if you sent this in error, let us know. And Renal responds with, oh, you can pull up okay, cool, yeah. So Renal responds with, yeah, it's an error, disregard, which isn't the rule. So Mark and I guess, it was a little bit underhand, but we just mapped out exactly what 10 days was, and that was the first Friday at trial. We know Alex Jones wouldn't testify until the second week. So we just kind of let him wait. It's not our fault that Renal doesn't know the rules, and we're going to use it to our advantage. So I don't know if anybody knows the clip, but I'm going to, so off of Twitter, we'll play the clip and then I'm sure where it goes from there. You don't know where this came from. Do you know where I got this? No. Mr. Jones, did you know that 12 days ago, your attorney's messed up and sent an entire digital copy of your entire cell phone with every text message you've sent for the past 2 years, and when informed, did not take any steps to identify it as privileged or protect it in any way. And as of 2 days ago, it fell free and clear into my possession. And that is how I know you lied to me when you said you didn't have text messages about saving voting. Did you know that? I told you the truth. This is your very next moment. I gave you my phone. And then Mr. Jones, you need to answer the question. No, I don't know but I mean. So maybe those questions are objectionable. We'll ask some of the judges, I don't know if you would sustain an argumentative or something like that on those objections. So
Gotta make an objection for me to rule on it.
that's kind of the point. If you might go to that PowerPoint. I will say, one of the most shocking things that's ever happened to me as an attorney is that man did not stand up somewhere in the middle of that long question to just make noise, right? And that's something I would recommend. If somebody's unfolding a Perry Mason moment in front of you, and you like clearly a movie moment, just stand up and doesn't matter what you say. So there's some options whenever you have an internet production. You can shoot on your fingernail. That would be ineffective, so I wouldn't necessarily recommend that one. And then obviously rule 193.3, which is why this is continuing legal education and not just making fun of people. So we'll go to the next slide. And I'm not going to read it, but it really only deals, the interesting thing that we sort of figured out was there's not a lot you can do about an inadvertent production of something that's not privileged or confidential. So if it's privileged, there's a rule on point that you have 10 days and you have to be real specific. You have to come back and say, okay, it's this document and this is a privilege, and the receiving party has to give it back. And you can go fight about it later on, right? You can say, we don't think that was privileged or whatever.
I have a huge question here. I always want, and maybe the answer is out there and I just don't know. I apologize for that. But you had a liability judgment because of all of his discovery abuses.
So, yeah.
How does he even have a privilege at this point?
Well,
it's arguably been waived.
But in what you don't even realize, judges, is before this happened, we had a motion for sanction on text messages. So we had obviously been asking for text messages for years. We had been told there are no text messages. There are no text messages about Sandy Hook. In the Connecticut case, in the depot, Chris Matty, their attorney, calls Mark and says, hey, what do you think about these new text messages that were produced? We're like, what are you talking about? And like, there's some text messages. So he sends 1 or 2 text messages to us that are relevant about Sandy Hook from Alex Jones. And we're like, so we actually had a motion for sanctions pending pre-trial. And then right before that, we get all of these text messages that are Alex Jones that deal directly with Sandy Hook when he had said for years that he didn't have them. But more importantly, Reynald had testified and told the court, there are no text messages. Well, they're in his possession.
Yeah.
So we weren't necessarily concerned with any privilege, really, any.
Yeah, I mean, even if he'd have clawed it back and done it right instead of not doing it right, then what ground are you going to keep from not producing it
right
at that point?
Right. Well, I mean, I think his, for instance, the text messages with dirty pictures of his wife to sit to Roger Stone, they probably gets that back. But not the stuff about Sandy Hook, right?
But even then, you still have to have an objection on the grounds of relevance.
Right.
Got to have something to hang your hat on. And I'm just assuming at the point that you have a liability judgment for discovery abuse, you've waived every possible objection.
Yeah, I think Judge Gamble would agree with that.
I mean, maybe people pictures, they go, okay, come on, guys.
Right.
But.
Well, no, I agree. I mean, if anyone was watching the earlier part of this cross, Alex Jones said, I don't use email. I haven't used email in 10 years. There was emails in his email address. So we're showing him these emails and, just watching him sort of lie, but fumble all over the place and not have a good answer. But yeah, I think that's exactly right. I mean, the texts were a big deal. There were some that ended up in evidence that were huge for our case. I mean, it really showed, he kept trying to say in trial, I've learned my lesson. We've changed the way we do things. We're a different company. We vet our sources, blah, blah, blah. Well, we had text messages from 2010 where so his producer, Paul Watson, had texted him, and there was an article up on InfoWars that they were saying COVID is fake. And they had a patient with being intubated. It was a dummy. And so the InfoWars was like, see, it's fake. They're doing these fake pictures and that's a dummy. It's not even a real person. Well, it was a picture from someone learning how to do innovations, like it was medical school. So Paul Watson had emailed or texted Alex Jones and said, hey, we have to stop this. This is Sandy Hook all over again. And Alex Jones said, yeah, I agree. That article was still on InfoWars when we were in trial. So they clearly hadn't learned anything. That was the point we were making. was you haven't learned anything.
I feel like there's so much criticism of the lawyers, and I'm not defending them for letting this have happened, but I'm like, what could they have done?
Right. So yeah, and you know, Judge Gamble gave them an opportunity toward the end of the trial to claw some back, but she gave them one day and they just didn't.
Not getting in there. I don't know what they could
I
have said with a straight face to the judge.
right, and had any credibility at all.
Yeah.
I mean, because you have both the party and the attorney clearly saying things that weren't true to the court. So why is the court going to give them any ground at all? But anyway, kind of what I was saying is what we sort of looked, no, that's fine. What we figured out was there's really not a lot of relief for inadvertently producing things that, because you just said that they're relevant. This sort of makes sense if you think relevancy. The idea is you don't put a burden on somebody to search for things that are irrelevant. Or to produce it, burden's done. But so you have the inadvertent for privileged information, and if you just go to the next slide, it's not much on it, but most protective orders have a clawback provision for confidential information. So if you ever do find yourself in this unfortunate situation where you sent your clients text messages to opposing counsel, you may look at your protective order that typically has some clawback for confidentiality. Anyway, that's one part of the trial. I'll let Bill take over.
Hey, everybody. So one thing I wanted to do is to give a shout out to our jury consultant, Robert Swafford out of Austin. He was fantastic. And he put us in a position and put Westfall, he's out of our Colorado office, since COVID at least. He put us in a position and gave us kind of the structure to where we could strike everybody that we needed to, and to strategically get us into a place where we could get a jury that we wanted. We're also in Travis County, which was shockingly less liberal than we thought walking in, but was also extremely liberal. So the $49.3 million verdict showed us how liberal they really are. But I wanted to give a shout out to Robert Swafford because he did a great job for us. I'm the speaker in the CLE that Mr. Herbert had to disclose that I would not do this in Harris County. And I would not do this in any case in any court, except for one where the discovery abuse was so bad on the other side that I got to try out all of the different tactics that I always wanted to in this case. And so I've got a couple of clips on some depositions. Everything's online. We wanted transparency when we did this case. And so if you go to our website, there's YouTube videos of depositions, Law and Crime YouTube channel has the entire trial. That you can go back and watch, because we could do 2 weeks straight every day on a different topic that popped up in this case in depth, and it would be extremely entertaining. It was a 2-week trial, and it was the most exhausting process I've been part of. I don't know about these guys, they've done trials a little bit longer than I have, but every day we had to pay attention to every single word, because so much just misinformation still 3 years after trying to get the right story was being spread on the stand. And so having to pay attention to someone talking and having to be prepared and know what you're going to do next was actually really exhausting for me. And I was the youngest one in the group. So I also want to say I'm not the smartest one at our firm by any means. These two guys are way smarter than me, but I was the sledgehammer during depositions. They got a lot of the sound bites that were able to be kind of pulled out and made for a really entertaining trial. But Kyle Farrar and Wes Ball at our office didn't get any money from George Soros. They funded this case completely on their own. And they gave Mark came in office in 2018 and was like, hey, Sandy Hook parents called me against Alex Jones. And I was like, I'm in. 100%. I didn't need any questions, any details, because I listened to Alex Jones when I was in college for entertainment, because it was JFK and that kind of sort of stuff. And it was entertainment. It was never news. In 2015-16 is when he took a right and got political, because he realized if he went one way or the other, it would monetize a lot more, and it did. Because the financials that are public record now, there were hundreds of millions of dollars were being made during this time. And the third most clicked story that InfoWars has ever made was about Sandy. And so going through and digging with their employees and their corporate representatives were on what the process was for them vetting the truth before they put it out there was fun. And this is a case that was not fun to try at times because we're dealing with a real serious subject matter. It's a real story and these parents went through it. But at the same time, for 2.5 years during discovery, Mark and I just enjoyed litigating against these individuals because they couldn't get it right. And by the time anyone with any competency that could have tried to save this, the hole was dug so deep and the sanctions were so bad already that there was no saving. On top of the default judgment, $1.4 million was sanctioned against Alex Jones before trial. And we've got pending sanction motions still for stuff that came out during trial and right before trial that hasn't been heard yet. So $1.4 million, I've asked a lot of judges for monetary sanctions before. I don't get them very often, and they don't have 2 commas. So, and that was all Mark
It's
Banks.
not over yet.
Yeah, right. I'll be asking. But Mark Bankson bludgeoned the other side, all 10 of them, on paper for 2.5 years, over and over and over again. So kudos to Mark. He was definitely the star of the show, and he probably has the most famous legal clip of at least this decade with that Perry Mason moment that we just saw. And having a defendant say, "Nice try on your Perry Mason moment," right before realizing, oh, this is about to be a Perry Mason moment, you can't write it. And there was a tweet by one of the writers for Law and Order during the trial that came across our computers that said, if anyone told me that story in a conference room pitching a show, we would fire them immediately because there's no possible way that would ever happen in real life. But here we are. With that said, we'll go to the next slide, please. There was some do's and don'ts in a deposition, and I didn't think I'd have to make this slide, but now in my career, I've learned that I should tell people about it because it actually happens. For attorneys taking the deposition, take control of the room. Westfall told me very early on in my career, he yelled at me because I hadn't taken control of the room in the depot that he was sitting in on, and it drove me crazy that he sat in on it in the first place because I knew he was going to say something. But he told me, that's your deposition. It's your court reporter. You take control. They don't get a say in what you are doing. They can object, but they've got 3 objections and you hold them to them. So you take control. There was 2 attorneys in the room when the deposition that I'm about to show happened. One was pro hoc in. His name is Robert Barnes, and he's very famous in quotes on InfoWars now because he's regularly there. He's also the attorney that represented the company on a pro hoc vice admission when they got defaulted. For some reason, Jones was like, "Oh, that's the guy we now want. Instead of representing us, we want him on air because he's for whatever reason." But Robert Barnes is not making any objections during my deposition, so I'm taking more and more liberties. I got to see where that line is because I'm advocating for my client. Another attorney, Mr. Enoch out of Dallas, who is the in-state attorney who sponsored the pro hoc, he starts making objections and commenting, and I wasn't ready to stand for him. So one person, I couldn't find a specific rule, but I've heard every judge this has ever been a part of say, one attorney, one witness. And I've lived by that. In the deposition clip, I may or may not cite a Texas Rule of Civil Procedure with no number that exists, but that's okay.
Well, there is a rule that says that the judge gets to control the mode and order of the interrogation.
In trial, 100%, but when we're in a depot, it gets a little bit uncertain, but I like to live my life as if I'm in trial every day, Judge.
And I do.
I'm aware, but I probably put that behind. So a bit of advice for everybody watching and listening is if you're going to get aggressive, like I do in this clip, you got to have on the white gloves. You got to be right, and you got to make sure that you don't have anything that's going to get turned around on you. So with that said, it's about 4 minutes, but it's somewhat entertaining, at least for me. Sociopathic as that sounds.
You might already agree, that's not a question, it's a statement. a spreading a statement of misinformation, correct?
But you're taking statements that are.
I'm asking a question. Correct. Here's what I'm. Don't interrupt the deposition, Mr. Enoch. Is what the question. If Mr. Barnes would like to do it, as he's defending this deposition you're seeing over there, I'm happy to entertain anything Mr. Barnes has to say. Because he's the one that's allowed to talk in this. Do you agree? Actually, we pause this for the time. Do you agree that only one attorney in Texas gets to defend a deposition and speak? No, I'm asking a question. Do you? You just interrupted my deposition. I'm asking, do you agree with me that only in pursuit of the rules, one attorney is allowed to defend a deposition? Or we just want to ignore the Texas rules? So is that what we're doing? I want to know why you keep interrupting. And what's the basis for that? I keep hearing you say those words, they're just not paying attention, keep interrupting and giving instructions. Okay, but before I go forward, I just want you to know everything you're saying is his job. If he's not doing it, talk to him and he can do his job. But your team decided he was defending the depositions, not you.
Pause.
Bill, are you thinking why?
It looks like wine is actually a Diet Coke at the time. But I had turned my phone on to record this because it had already started about 3 questions before. And this is day 2 of depositions. Day 1, Mark took, and the same thing started happening. And so I coined this line, which actually isn't really true, but they think the other side thought it was, which was, this happened yesterday and Mr. Bankston's the nice one. And Mark was not nice day 1 about it. So they had their warning, and that's why I hit record on it. But that is a little bit of, yes, I definitely talked down to him, and I definitely conducted myself in a way that typically never in any other case had. But that's because this is after probably 15 different times of warning them to stop, and they wouldn't. So, I'm the bully that bullies bullies, I guess you could call it, out of some of these. The witness is just begging for help at this point because he's just told me that he produced stuff, not without realizing they haven't produced anything. They didn't answer discovery in this one because there was so many cases going on at one time. And this is the corporate representative that they chose for the first 2. After we got done with the second one, they decided, let's give somebody else a try. So they gave it to somebody else. Let's start with the second one. And the next slide, please. Oh, the one up. How to deal with a lying witness. Well, you saw Mark do it in trial, which was fantastic. It was the most entertaining thing. And there's a picture of me like this, and then a bunch of people on the internet decided to start making memes out of it saying, find you someone who looks at you the way Bill looks at Mark in trial. Because I'm just like, one of the news agencies got that photo. But this is going to deal with the second corporate representative deposition, same witness, Rob Duke. And in this one, he decided to wear a Kangol hat, which I loved. Walking in, I was like, all right, we're off to a good start. But the first corporate rep, they talk about an employee that they had, and they say, oh, we fired him for what he did during his Sandy Hook coverage, which was they had an individual fly to Connecticut and berate government officials and attorneys in horrific ways, walking down the street, trying to just leave them alone. And this guy was an ex-cage fighter. They call him the Kraken at InfoWars, which was the greatest thing for us because we get to call him that during trial and during demos. So first corporate rep that we just saw, they say we fired him for what he did in Sandy Hook. Then they disclose us a few documents in between these. And one of the documents has an email asking for the same employee to give him stuff 3.5 years later. So the corporate rep, after I start questioning him, is like, oh, no. So you can play the next clip.
So in this case, for the first time, you were involved in the taking of Tommy being fired. Tommy was acting with Donald Trump route in 2016. Right back, right?
So it's always good when you say fun fact, right? Because at least when I say it, it's very sarcastic. But then when the witness says that is a fun fact, it's just like, whoa, yeah, you got me there. So the clip was a little bit longer, but it wouldn't compress correctly, which is why the audio is a little messed up. But I lead him into this of, remember when we talked last? This is what you told me. This is why he was fired. He's like, absolutely. I'm like, all right, let's look at this piece of paper. And he's reading it and he doesn't realize what it says. And so that's when, here it is, 3.5 years later, you guys are still employing this person. So how to deal with a lying witness is, if he lies to you, establish what it is, give him a piece of evidence or testimony that shows that they're a liar, and then ask them how fun of a fact that is to learn that they're lying. That's my approach to this. You go to the next one. Listen to the witness's answers. I teach, or I used to, I haven't since COVID, but I coached the mock trial teams in South Texas. I was a mock trialer there. I think that put me in the best position, other than the tutelage of Mr. Farrar, Mr. Bankston, and Mr. Ball, for me to get to where I was at a pretty young spot in my career. I'm way younger than they are. The beard, they got a decade on me of knowledge to share, but listen to what they're saying. Don't worry about your outline. Your outline's there for when you get lost, not for when you need to know what your next question that you wrote out is. Ask them a question. If they give you an answer that you like, ask more questions about that answer. Don't just go to the next one because that's what you typed out in your head. Because one, it's way more effective and comes off better. And two, they're going to step in it. So what I love to do is when a witness uses a word like negligence or liability or fault, I say, you just said negligence. What's that word mean? And then their objection asking for a legal definition. I'm like, no, I'm asking what he meant by it. So the witness now has to say what they think that word means. And it's never good for them. It's never right. So in this deposition, this is Owen Schroyer, who is an on-air talent, we could say, I guess. Talent is liberally used there. For InfoWars, and he was the individual who pulled up a story and accused our client, Neil Heslin, of never holding his dead child. Heavy stuff. Leading into this, I asked him, you just said mainstream media. What's that mean? And he gives me a 4-prong test. They have commercial sponsors. They have a large audience. They have a reputation in the news community, and another one I can't think off the top of my head. So as he says that, I'm just checking the boxes. InfoWars checks every single one. So I follow up based on his answer with, well, InfoWars is mainstream media. And he's like, absolutely not. I'm like, oh, let's go through that definition again. So we walk through it, and this is kind of just using his own words against him in a deposition. I find it extremely effective. If you ever do it, there's not a right or wrong way to do it. The witness is, unless you're deposing another attorney, the witness is never going to give you the right definition. They're going to give whatever their a lay person or what their personal definition is. It's always going to be persuasive to what they're trying to get across. It's always going to hurt them. So, play the next one.
Others who InfoWars in yourself on the platform from social media outlets. Others the InfoWars mainstream. Yeah, okay. They are not involved in the right, massive audience that having clicks, most of the company flash and show. Right. And one of the that wasn't accomplished, the sponsors didn't have generation. We have that. So I just want to get even worse. Checks all of the boxes for mainstream media. Whatever they use. I just feel agree to check all the boxes. I don't agree that there are boxes. Again, they turn around and buy it. Mainstream media, somebody who's the big and hard to agree. I'm so asking for you to come as somebody in the rest of everyone else. Right? That's the work you think was Owen's family. In practice. It's like there was this mainstream. You gave me your criteria. And so you will serve for you. And it checks every single box. But you're saying, no, we're not mainstream. You're not trying to figure out what. So, okay. How about this? When we slide up in this, the governments and others that kind of, anybody can be super important. So the reason we're covers based on how we have information. You ever seen information works in the United States? I'm not saying everyone, but I want you to Google it when you go on. I want you to see those minutes on paper. Well, that, if there ain't some, see it, every culture, maybe basketball, the whole. I mean, what do you say? Still, you live in the scene just makes up and nobody notices. I am sure that it's your reference. Go to your job. Surely you recognize one. Very good. So, because it wasn't true, we found the image of it. So, we're going to go around and do the short test for mainstream.
And they'll do it over and over and over again. You're right. You're exactly. I gave a disclaimer beforehand. I wouldn't conduct myself like this in every case, but this is at the end. I'm frustrated not only from this deposition, but from everything that's already happened. And so, yeah, if they say if somebody uses a word, use it against them. They're never going to be right. And even if they are, if you can think quickly on your feet, you can twist every single definition unless they read something out of a Merriam-Webster dictionary or off of a Black's Law dictionary. You can always use it to your advantage if you do that. In trial, never ask an open-ended question. Keep your cross-examination nice and tight. But this is how you develop sound bits for the leading questions, which is I ask a lot of open-ended questions. The first, after asking to introduce yourself to the jury in the deposition, my second question to every witness is, why do you think you're here today? 85% of the time, they give a terrible answer. I'm here today because I negligently, did this, that, and the other. And I'm like, all right, now we've established that. Let's move on. And then here, my question that he walked into, all I asked was why? Why? And then you can say, well, let's see. And anytime they say, let's see, they don't know the answer they want to say. And they're thinking quickly. It's typically not good for them. And here, we were so much more prepared for them that no matter what they said, this was going to happen, which is why it was enjoyable. It made practicing law a lot more fun, and it kind of motivated us to bring on more cases. For older attorneys in the room or listening, if you have young associates, let them do stuff. 3 weeks into being licensed, Kyle, Farrar, and Mark asked me to take a deposition of an expert witness in federal court in front of Judge Hittner, who is very friendly to me at times. Yeah, I have nothing wrong with Judge Hittner, but I did have to order a transcript one time based on what he said or did not say regarding myself. Thanks to Kyle. But I took an expert deposition. In that expert deposition, we went to trial. We got poured out. Went up to the Fifth Circuit and made great law based on what was in that. So if you've got young attorneys, let them do stuff. We want to. I wanted to. Now I'm older. But one thing about our firm is they let us do whatever we want. They trust us. We trust them. Kyle never asked us once how much money we're spending, which is his negligent decision to ask. But he trusts us. You don't get that freedom right off the bat, but you earn it. And Mark and I definitely have based on this case, and in all of our other cases. And if you you've got an associate that's passionate about a case and brings it to you, if you can make it work, let them do it. They can, because letting them do that will motivate them to do all the other cases that maybe aren't as interesting to them, or it'll allow them to find an excitement in the profession that gets us back to producing good work product consistently. So yeah, shout out to Wes and Kyle. They let us do whatever we want and have for a long time, and just got lucky that we haven't screwed up too bad just yet. So I think with that, we would welcome any questions anybody has if they want to type them out on the live stream or raise hands. And
so there are several people that let me know they've got kind of a hard stop at 1 o'clock. These guys are going to come upstairs, I think, and answer any questions you have. If you've got any amazing brainbuster question, you feel like the world cannot live without you asking, now would be a great time. But I do want to be respectful of folks' time. I know some folks really need to get going. If I effectively discouraged all questions.
Good word, buddy.
I've got a couple of quick announcements. First of all, Judge Garrison, Judge Engelhardt, thanks for joining us. Always wonderful to have.
Inviting us.
Yeah, love having members of the bench here. They ask the best questions. Thanks, Judge Engelhardt. And Judge Garrison. Couple of quick announcements. We are going to do this again next month. If you've got any ideas for topics or speakers that you think would be a great fit, there's no particular formula for this, so please email me. I'd love to hear about it. Two, we have some cups and swag and fun stuff upstairs. If you can't stay for lunch, please at least stick your head upstairs and grab something. There's some kind of fun treats up there. Two, we had an inordinate number of attorneys not provide their bar number. If you did not provide your bar number, I can't give you credit. So please either email me or grab one of the sign-in sheets. There will be one upstairs as well. But if I don't have that bar number, I can't just give you credit. You have to tell me who you are. Finally, Mark was kind enough to join me on a podcast a couple of days ago that will be available today. I'm going to send out that link to the emails you guys provided. It's kind of a deeper dive into some of the more absurdities that came out in this trial. And if you want to listen to it, it's pretty entertaining. But I'll make sure we send out an email to everybody with that link probably this afternoon. So with that.
I got one more thing. If you find yourself in a case about defamation, call Mark. If you find yourself with questions about pretrial publicity, call Mark. He knows these rules better than anyone. He's the one, we had to learn on the fly with this, but if you find yourself with an interesting issue or case, give us a call. We're not going to try to, get you to refer it to us. Frankly, we've got enough of that. But yeah, we're happy to give you our, best advice on what we've run into and what we learned in the process. So,
and I want to thank you guys, Bill, Kyle, Mark. Great job on this case, and thanks for sharing your time with us today. So.